new developments out of Massachusetts where the judge in the Karen Reed case has denied the Commonwealth's motion to access Reed's parents' phone records ahead of her second trial. Prosecutors had filed a motion seeking a month's worth of William and Janet Reed's phone records from 2022 in hopes of showing that it was unusual that Reed had called her mother 3 times on the night that her boyfriend, Boston police officer John O'Keefe, died. The Commonwealth went on to say that this would provide strong evidence that Reed, quote, knew she had done something terrible, struck John O'Keefe, or left him behind, unquote. And now I'd like to share my thoughts from the bench on this ruling. This is a really great example of you can't just get everything you want to try a case because you think it might be helpful or because you ask. Evidence that you are seeking to obtain and or use in trial must be relevant. That means it must be logically connected and tend to prove or disprove the matter in issue. If there's too big of a disconnect, then it's likely not relevant. Note that the judge in this case found that the affidavit in support of the state's motion to get 1 month of cell phone records of the parents of Karen Reed is, quote unquote, insufficient on its face and fails to meet legal requirements. But even more important to note is that she made that finding because she said the affidavit did not show that the records were relevant with specificity, meaning you have to be very specific as to how and why they're relevant. This is a case I absolutely agree with the court's ruling because you're taking into account as well that the prosecution already has the phone records and cell phone data from Karen Reed's phone. What a stretch to say we also want it from the parents' phones. I don't think it's relevant. I think the judge made the right decision in this case. Let us know what you think.